Chapter 18, we talk about employment law, which I think is one of the, other than the ethics chapter, this is probably one of the most important chapters in the book, because you'll either be an employee or if you're a small business owner, you'll be an employer. So it's very important to understand these laws and to live by them and to have those expectations in the workplace. So Ohio is an employment at will state, which means that either you can quit as an employee at any time or your employer can fire you at any time or let you go at any time. The only exceptions to that are listed there, but there's a contract theory. So if they have a policy, whether it's stated and in print or implied, they can't violate that policy. So say the policy says you're allowed to be late 3 times before they write you up or 3 times before they fire you. Well, then obviously the very first time you're late, they can't fire you because that would be contrary to their stated policy. So the employer does have to live by that. If it was the next one, it would be intentional. They caused you intentional emotional distress. So they maybe fired you in front of the whole work crew and was horribly rude about it. Or if you had fraudulently misrepresented yourself when you get hired. So those are going to be things that could fall into that tort theory. Or then public policy, like say your employer wanted you to do something that was illegal. So say, a customer overpaid and you knew it. And everybody knew that they double paid that invoice and the employer said, hey, you just need to pocket that money. Not you personally, but the business is just going to pocket that money. Well, you wouldn't have to do that. I mean, you could stand up and say, hey, no, that is a violation of the law. These people overpaid us. And if you did that and they fired you, then that would also be contrary to public policy. Or if you blew the whistle on them, so say you knew they were doing something illegal, maybe they were violating accounting policies, maybe they were dumping, waste in a local river or something that was environmentally wrong, and you blow the whistle on them, they also can't fire you for that. And there's different statutes now. I mean, there's 1-800 numbers supposedly that you can call where you will be anonymous to try to protect employees from that whistleblowing termination. Then we get into our Fair Labor Standards Act, which basically sets forth in the United States that we can't have child labor. So only you can't obviously work somebody who's less than 14 years of age. From 14 to 16, they can work very minimal hours. And under 18, they couldn't work at hazardous jobs like coal mines or a steel mill or something like that where it could be considered hazardous. Minimum wage must be paid. The law also requires that employees who work over 40 hours a week will get paid overtime. Now, if you are like a manager or a supervisor or an accountant or whatever, and you're on a salary compensates you for when you're expected to work overtime. So you don't get overtime, you just get your salary. But anyone who's like clocking in, so like factory workers, hospital workers, store clerks, people like that, if you work over 40 hours a week, you should be getting overtime pay, which is time and a half. Okay, then our Family and Medical Leave Act. This is applicable to larger employers. So the employer has to have over 50 employees. And then what's required is they provide unpaid leave. So notice that's unpaid. They don't have to pay you during your time off. They just have to allow you to take time off and guarantee that you have a job when you come back. So that's really the key to that, is that you won't lose your job if you have a medical illness or your child has a medical illness or you have a baby. So things like that. Okay. OSHA, or our Work Health and Safety Organization, which again is OSHA, Occupational Safe and Health Act, is what governs that. And those are mandated by federal law in the United States, and they're aimed at providing safety in the workplace. So following OSHA, all employers have to report any work-related accidents that occur on the job. And OSHA can just randomly show up and kind of walk through your facility to make sure everything's kind of up to code and that, the workers are obeying the different rules. When I first graduated college, my second job actually from graduating college, I worked at a plastic injection molder. And, that area, if you're working those presses are very large. And you're working with these plastic parts and you're cutting little pieces. So out in the plant, you had to wear safety glasses if you were out there around those presses, again, because there's hot liquids, there's those little plastic pieces that are coming off. And there was certain areas, like if the press was being worked on, obviously the employees would have to clear out that area. Only the maintenance guy could be in there. The safeties need to all be working and in place. So then OSHA is the organization that kind of maintains some of those laws. We also have workers' compensation. So the state of Ohio has its own workers' compensation plan, and employers that have employees have to pay into workers' comp. So depending on what field you are and what your claims are, there's a certain percentage of the wages that the employer has to pay in. And then that worker, though, is then covered under workers' compensation laws. So if they are injured on the job during their course of employment, then they can have a workers' compensation claim. And then that workers' compensation will pay for the time off as well as any medical costs. Then we get into our different kind of taxes. So as an employer and an employee, and you're having your taxes coming out of your paycheck, you will pay into your Social Security, and your employer will match that contribution into your Social Security. And that piece of your paycheck ideally is going to be setting aside money for when you retire, and hopefully we'll all be able to collect that Social Security at that point. And that's up to a certain dollar amount. It changes every year. Up to that point is what you have to pay into. Then Medicare, there's no dollar limitation, so everybody pays their whole salary. There's a percentage of that goes into Medicare, and that provides for health insurance for retired and disabled people. And again, the employee pays and the employer matches. Employers can have private pension plans, or most government jobs offer private pension plans. So those, again, are normally the employee pays in and the employer matches it, but there's more of a guaranteed amount of your salary that you're going to get once you retire. So it's a little bit more stable and a higher amount than the Social Security system. And many employers would be both. You could be paying into a pension and paying into Social Security. Most government jobs are just pension only and no Social Security. Unemployment insurance, your employer pays into that. So then if you need to collect, the employer has been paying in a certain percentage of their payroll all the time. So that is where that is going to come from. COBRA allows for, and these days it might be longer now because that recently changed. But COBRA allows for you, if you lose your job or you get laid off, to maintain your health insurance. And you have, I think you can do it for more like 6 months, where you can pay. You got to pay for it though; it's not for free, but you'll pay into it so you can maintain your health insurance until you either find another job or find a different health care plan. And employer-sponsored group health, that's not required by state law. Most employers do offer it because it's a benefit that people expect, but the federal government does not require that. Employee privacy. I think this is a big one because I don't think people completely understand that when you're in the workplace, you can be monitored in a variety of different ways. So they could be monitoring you with camera. They could be monitoring the telephone calls. They definitely monitor the computer usage. So as long as they've notified you, whether it's in their policies or it's posted in the break room or whatever, that's their notification to say, hey, we do electronic monitoring in the workplace, and you just have to be very careful that you're following those. So for instance, emails, you've got to be very careful that if you're using your work-related email, that you are only sending out emails that relate to work on that. So don't use your work-related email as your personal email. Have two. I have seen people that have actually been terminated for that. So even though you think, oh, what's the big deal? It all depends on the employer. So if they tell you they're monitoring it and they tell you not to do it, I wouldn't do it. I would have a personal email where everything goes to. And your internet, pretty much everybody has internet access on their computers now. Be very cautious about what you're using because they will monitor that. When I worked at the oil and gas company, the CFO's big pet peeve was a couple things. One, what people were looking at the internet, was it work related? Was it not work related? And he would monitor the time. So there was a report that came out every Monday morning of the top users of the internet and what sites they were on. So in the accounting department, you better hope you were not on that list because you were going to be in some serious trouble. And then the other thing he didn't like is when people played like solitaire or those games, and he would send us an email. He'd say, if I walk by your office and you've got solitaire up on your screen, you're going to be fired. So, he gave us warning. But so those were his pet peeves. And as long as they're clear about it and it does not relate to your job, you have to abide by those. So just be very cautious. Drug testing, a lot of companies require drug testing before you get hired. Some will do random tests during the year, and some will do it only if you've been injured. So like at the plastic injection molder where I worked, we didn't drug test even before we hired the people. We only drug test if they were if they were injured on the job, then we drug tested them. And that was it. But I know like at Stark State, I had to be drug tested before I got hired. So every employer is a little bit different. Immigration laws. So employers have to verify that their workers have the ability to work in the United States. So whether they've got like a green card, or they've got that I-9 that says, yes, they're able to work, they still need to withhold taxes and do everything that you would, and provide all the same, OSHA standards and all that stuff as you would for a citizen that's working for you. If an employer is taking advantage of those immigrants and not paying taxes and kind of paying them under the table, they could be fined for that. So I guess just bottom line is you basically have to treat them the same as you would, a U.S. worker and withhold taxes and do everything right. And, I guess that's going to keep you from hiring any illegal immigrants. Then we get into employment discrimination. So there's a whole variety of ways that people can be discriminated against. So there's race, color, national origin, your religion, gender, age, and disability. If you fall into any of those classes, you are considered being in a protected class. So like for me, I would be in the gender because as a female, I am considered, a protected class. I'm not a male. A male is still the predominant gender at this point. And then age. So I'm going to be 50. So that puts me in the above, I'm in the older working American category. So that also puts me. So I'm in two protected classes. So you could find yourself in a variety of different classes, again, depending on who you are, unless you're just an average white young man, then you're in none of these protected classes. But if you're not an average young white man, then you'd probably find yourself in one of those. And then the EEOC is the Equal Employment Opportunity Commission. They are going to monitor that to make sure people are not discriminated against. And you could file, a lot of times people contact attorneys, but you could file a claim directly with them. So there's two different types of discrimination. So there's the disparate treatment discrimination, where it's what they call a prima facie case, where there's basically an inference of discrimination. So say, for instance, again, I'm a 50-year-old woman and I go and I apply for a job or I apply for a promotion, and then a 40-year-old, now let's make a 35-year-old white male gets the job, but I've been there longer. I maybe have a certification that he doesn't have. I seem like I would be a more qualified candidate, but I don't get it. Well, that would be a prima facie case. It appears that discrimination happened. Now, maybe they could come back and say, oh, but we liked his personality better. We think he'd fit in our corporate culture, whatever. But just kind of looking at it from the outside, it would appear that there was some discrimination in that hiring or that promotion. So that's what we call more intentional discrimination and that disparate treatment. The disparate-impact is more unintentional. So it comes back to their hiring practices. So say there's a test, like and I think the Timken company has a test like this to work in their factories. But these could be legitimate tests. And I think like maybe UPS does this as well for drivers, because the job entails you lifting so much weight or moving things that are, again, so much weight. They're going to test you on that. Can you bend and lift and move and put something up high and move something over here? They're going to put you through that test to make sure that you have the physical capabilities to do it. Well, obviously that test is going to have a preference for men over women just because of the nature of the physical endurance. So then if say with the Timken company, if we have a woman who's applying for that job and then they hire nothing but men. So if you go into that factory and there's nothing but men in there, that could be this unintentional discrimination. Again, they would take a woman who tries to get the job and who really can lift the 40 pounds and all that and not getting it. Well, I guess that if she could lift the 40 pounds, she probably, hopefully, then we'd go back up into the top one. But so say, if a woman would claim that I could do the job, even though this test is like super hard and I'm not able to pass it, kind of a thing, that would fall into that category. Then we have, again, getting into a little more details. So race and religion. The religion in an interview or anything that you're doing of any type of job hiring or promotion, nobody should ever ask you about your religion. That would be a definite no-no. And if they did, you would not have to ask it. Now, the only thing I will say, though, say you are going to apply it like a Christian university, like I'll say Malone, for instance. So Malone, because they are a Christian university, they do ask for your religious belief statement, and then they are allowed to because it's applicable to the job. But say you're just, going to work at a restaurant, they can't ask you what religion you are. But once you're employed there, they do need to reasonably accommodate your religious beliefs, unless they're so small that it would cause them undue hardship. So say they have 5 employees and you say, I need off for, this religious trek that I'm going to take over Christmas. And they're like, well, no, I can't because, we only have the 4 employees and we can't do that. They would be allowed to. Now, if they had 100 employees and it did not cause them undue hardship, and for whatever reason, this was very important to your religious beliefs, you had to have this day off or this time off, then they could not say no. They could get into trouble if they said no. And we cannot classify jobs as male versus female. So we can classify, like I said, going back to like that Timken example, you could say you must be able to lift a certain amount, you must be able to, work these hours and all this kind of stuff. But you can't say I need a male worker for that or a female worker for that. So gender cannot be specified. The constructive discharge, that would happen if the working conditions become so intolerable that they're basically forcing you out the door. So, again, it would have to be pretty severe. When I worked at the oil and gas company, we kind of did, it was that CFO, that same one that had issues with the internet. If he got a person that he didn't really like, and didn't think they was doing their job real well, what he did is he would pull work away from you. So before you know it, you had no responsibility. You had nothing to do. So, he never fired you. But so normal people can only do that for so long. Like when you go into work and think, I have nothing to do, I have no job responsibilities. So to me, that's an example of constructive discharge. The thing is, the working conditions were not intolerable, so no one really could plead that. But that was kind of what he was trying to do, was just make it so that, you knew you had to go find another job. And people eventually all did do that when he would kind of do that. But if they made it so that it was really bad working conditions, then that could be a case that you could file against the employer. Whoops. Sexual harassment. There's two types of sexual harassment. There's quid pro quo, which is like, hey, I'll give you a promotion if you do me a sexual favor. Which, you know, the news has been plagued with those recently, especially in the media and the you know, like filming areas. I feel like all of our news anchors and our movie stars are all getting hit with that. So that's something that definitely had been happening maybe in the 70s and 80s. But that would be an example of quid pro quo. The hostile work environment is when the environment that the person working in is so sexually offensive that it becomes a hostile environment and they would need to get out of that. So it could be maybe vulgar emails, maybe posters of naked women or naked men, offensive, you know, porn type sites that the people are on. Like any of that type of thing is going to create the hostile work environment. So it's not that favor for a favor, but it's just not appropriate behavior and more of a sexual nature that can cause that hostile work environment. So then sexual harassment, this is good to know this as well, whether you're an employer or a worker, but the supervisor the employer is going to be liable for a supervisor that does any type of sexual harassment of their workers at all. So whether they knew whether the employee had complained about it already or not. So then that's what that message is sending, is that if you're going to put somebody in management or somebody in a supervisory role, you better make sure that you know that they are good quality people and that they're not going to do something like that, because the employer will be liable for their actions. If it's a coworker, so it's just, you know, somebody sitting in the cube next to you, the employer is only going to be liable if you go and complain. So if you go to HR and say, hey, the guy in the cube next to me keeps watching porn and I find it offensive, or the guy in the cube next to me or the girl in the cube next to me is saying, you know, sexual comments to me every morning and I can't take it anymore. Then if the employer knows that and does nothing to discipline that person or to deal with the situation, then you could sue them. The non-employee comes into the case like with the customer and the waitress, or the customer and a bartender. I'm sure this happens all the time. So a waitress walks by and a customer grabs her, you know, inappropriately, or whistles at her or does some sort of a cat call. Well, if she goes to her boss and says, that customer over there is sexually harassing me and I'm not going to, I don't even feel comfortable walking by him anymore, that manager of that restaurant needs to go over and either ask that person to leave or ask them to, you know, to stop. If they do not, then they would again be liable to that waitress for that harassment. Same gender harassment is definitely occurring, you know, in today's environment, or just even gender-based harassment. So to say that, you know what I mean, if we have somebody who is bisexual or transsexual, those people can also not be harassed. There can be no comments, there can be nothing negative said to them. So we have to be very cautious that is not occurring in the workplace. Online harassment, again, can happen, emails, things like, you know, things like that you put on your Twitter, your Facebook, anything like that has to be watched. And actually be careful of anything you put on your Facebook, because people are fired for that as well. So what remedies can happen if we lose our job through discrimination or sexual harassment or something like that? You can go to court and you could get your job reinstated. You could sue for back pay. You could sue for a back promotion. And the damages could be compensatory. So again, they're going to compensate you for what you lost. Or punitive, where they're, again, punitive, if you can remember back at the beginning of the semester, we talked about punitive damages. those are awarded to punish the wrongdoer. So they're going to make a point of punishing that employer, that large company that allowed that to happen. The courts don't want them to go unnoticed. So then those punitive damages can come in. And so some or all of those damages could be awarded. So age discrimination, see, it's over 40. So to me, 40, it's because I am over 40, but 40 doesn't seem that old anymore. So I feel like a large chunk of our workforce is actually in this age protected category. So again, if we're, like my example before was, if I was qualified for that position, whether it's a promotion or a new position, and it was filled by somebody under the age of 40, but I had more skill, that could be a case that I could have. Disability, there's a whole list of different disabilities. So I mean, you can kind of read through that, but I mean, there's a wide range of disabilities that are protected under this Disability Act. So basically, if you would have a person who is disabled applying for a job, you could not say, I'm not going to give you that job because of your disability, unless it would cause undue hardships to accommodate them. So say you have an accounting office on the second floor of a building that does not have an elevator, and somebody in a wheelchair applies for the job. They could be totally qualified for it, but we have no way of getting them up to the second floor. We can't put an elevator in. There's no way to put a ramp in. So then you could say, I'm sorry, but it would cause me undue hardship to accommodate you, and that'd be okay. Now, if you're the Timken company or a Diebold company or a huge company, that is not okay. You should have a ramp to get to every place in your building, or else an elevator. So again, it depends on the size of the company. So there are some defenses. So these defenses says, okay, I'm the employer and I've got this case. What can I come back and say? So it could say that it's a business necessity, so that I require a high school diploma or I require a college degree, and it's necessary for that particular job that we're doing. It could be a bona fide occupational qualification. So this is kind of where that gender specific could come in to say, so say I'm looking for a male model. I mean, most women, I could dare to say all women are not going to be able to fill that mold. Again, it depends on what type of a male model it is. But if you're looking for that rugged, kind of male model, obviously it has to be a man. Same thing. If you're a female and you're looking for a bra and underwear, Victoria's Secret kind of a model, obviously a male cannot do that job as well. So there could be some bona fide occupational qualifications that could be related to that. Now, race is never, ever a bona fide occupational qualification, so that would never qualify there. If someone's being discriminated against for race, the employer couldn't come back and say, well, that was a bona fide occupational qualification. And then after evidence of employee misconduct cannot be used to shield liability. So again, you can't like go on a witch hunt and go back for 2 months and inquire a bunch of stuff before then you fire that person. Okay, so that is chapter 18. So again, very, very relevant stuff in there to understand and to kind of get comfortable.